A federal court just delivered a ruling that could reshape the entire magazine ban debate across the country, and the ripple effects are going to be massive. This isn't just another lower court decision that fades into the background. This one directly contradicts what other major appellate courts have already decided, and that kind of conflict between courts is exactly the trigger that forces the highest court in the land to finally weigh in. What just happened, why it matters, and where this is all headed? Let's get into it. The ruling comes out of Washington, D.C., and it involves a case called Benson versus the United States. The facts themselves are straightforward enough. Police stopped a man named Tyree Benson and discovered he was carrying a firearm equipped with a standard capacity magazine. Now in D.C., possessing a magazine that holds more than 10 rounds is a criminal offense. They classify anything above that threshold as a so-called large capacity magazine, and merely having one in your possession can land you with serious charges. Benson was hit with multiple counts, including the magazine possession charge, and he decided to fight back. His argument was simple but powerful. The magazine ban itself violates the Second Amendment. That challenge is what set the stage for everything that followed and ultimately produced this landmark decision on appeal. Now here's where the case takes an unusual and frankly fascinating procedural turn. Originally, the United States government was the one prosecuting Benson and defending DC's magazine ban. That is standard procedure for criminal cases in the district. But during the appeal process, a change in presidential administration completely altered the dynamics. The new administration adopted a firmly pro-Second Amendment posture, and the federal government did something you rarely see. It switched sides. The United States actually conceded that DC's magazine ban violates the Second Amendment. The federal government essentially told the court that upon further review, this law is unconstitutional, and we cannot in good conscience continue to defend it. That left DC itself scrambling to step in and defend its own ban. Under the court's procedural rules, the district was allowed to intervene and continue arguing that the ban should be upheld, even after the federal government withdrew its support and joined the other side. So you had this remarkable situation where the entity that originally brought the prosecution was now aligned with the defendant, arguing together that the law should be struck down, while the District of Columbia was left trying to hold the line on its own. That alone made this case extraordinary from a procedural standpoint, but the substance of the court's final ruling is what makes this decision a potential game changer for Second Amendment law across the entire nation. The DC Court of Appeals ultimately sided with Benson and the United States. They struck down DC's magazine ban and ruled that it violates the Second Amendment. What makes this opinion particularly significant is the way the court reached its conclusion. The reasoning follows the analytical framework established by the Supreme Court in two landmark cases, District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruen. Those two decisions laid out how courts are supposed to evaluate Second Amendment challenges, and this is one of the clearest examples we have seen of a court faithfully and rigorously applying that framework to magazine restrictions. The court did not water it down. It did not try to work around it. It applied the test as written, and the result was decisive. The court made three critical findings that form the backbone of this ruling, and each one carries enormous weight for how these cases will be evaluated going forward. The first finding addresses whether magazines even qualify as protected arms under the Second Amendment. The court answered that question with a definitive yes. Magazines are essential components that allow modern firearms to function as designed. Without a magazine, most contemporary firearms simply cannot operate. They are not accessories or optional add-ons. They are integral mechanical parts of the weapon itself, and because of that, they fall squarely within the scope of Second Amendment protection. This matters because one of the recurring arguments from the other side has been to try to separate magazines from firearms and argue that restricting a component is somehow different from restricting the weapon. This court rejected that logic entirely. The second finding addresses the question of common use, which is a critical legal threshold under Supreme Court precedent. The court found that magazines holding more than 10 rounds are unquestionably in common use throughout the United States. The numbers here are staggering. There are hundreds of millions of these magazines in circulation across the country. They come standard, not as upgrades, not as aftermarket modifications, but as factory standard equipment, with many of the most popular firearms sold in America today. When you purchase one of the best-selling handguns or rifles on the market, the magazine it ships with from the manufacturer very often holds more than 10 rounds. That is the default configuration. The court recognized this reality and acknowledged that these are not fringe items possessed by a small subset of gun owners. They are mainstream, widely owned, and commonly used for lawful purposes including self-defense, sport shooting, and training. Under Supreme Court precedent, this common use finding is enormously important. The Supreme Court has established that arms which are commonly owned by law-abiding citizens for lawful purposes cannot be subjected to categorical bans. You cannot simply outlaw an entire class of arms that the American public has embraced as standard equipment. That principle flows directly from Heller and was reinforced in Bruen, and this court applied it exactly as the Supreme Court intended. This naturally led to the court's third and final major conclusion. The District of Columbia tried to argue that there was a historical tradition supporting bans on these types of arms, which is the test that Bruen requires. Under Bruen, the government must demonstrate that a modern firearms regulation is consistent with the nation's historical tradition of firearms regulation. The court examined the historical evidence presented by D.C. and found it woefully insufficient. There is no historical tradition in this country of banning arms that are in common use by ordinary citizens. The court was thorough in this analysis, and the conclusion was clear: D.C. failed to meet its burden. The magazine ban has no adequate historical analog, and therefore it cannot survive constitutional scrutiny under the Bruen framework. Based on these three findings, the court reversed Benson's convictions related to magazine possession and effectively struck down D.C.'s ban on magazines holding more than 10 rounds. That alone would be significant, but the broader implications of this ruling extend far, far beyond the borders of the district. Here's where things get really interesting, and this is the piece that could accelerate the timeline on resolving this issue nationally. Several other federal appellate courts have already reviewed the constitutionality of magazine bans, and they reached the opposite conclusion. The most prominent example is the Ninth Circuit's handling of Duncan versus Bonta, which challenged California's nearly identical ban on magazines holding more than 10 rounds. The Ninth Circuit, sitting as a full-on bank panel, upheld California's magazine ban. They reviewed the issue multiple times through various procedural stages, and each time they concluded that the ban was constitutional. The D.C. Court of Appeals was well aware of this contrary ruling, and they did not shy away from addressing it. In fact, the opinion goes out of its way to dismantle the Ninth Circuit's reasoning in Duncan. The D.C. Court criticizes the Ninth Circuit's analysis and essentially says that the Ninth Circuit did not faithfully apply the Heller and Bruen framework. The court argues that the Ninth Circuit got it wrong, that when you properly apply the Supreme Court's own test, these bans cannot stand because the magazines in question are in common use and there is no historical tradition supporting their prohibition. This creates what legal scholars and practitioners call a circuit split, and in the world of constitutional law, circuit splits are enormously consequential. A circuit split occurs when different appellate courts interpret the same constitutional provision in fundamentally different ways, resulting in the law being applied one way in one part of the country and in a completely contradictory way in another part. If you live in California and fall under the Ninth Circuit's jurisdiction, magazine bans are currently constitutional. If you are in D.C. under this new ruling, those same bans are unconstitutional. That kind of inconsistency in the application of a fundamental constitutional right is precisely the type of conflict that the Supreme Court exists to resolve. Resolving circuit splits is one of the primary reasons the Supreme Court grants certiorari in the first place. When federal courts start reaching irreconcilable conclusions about what the Constitution means, the highest court has a duty and frankly an institutional imperative to step in and provide a definitive answer. This brings us directly to the current status of Duncan versus Bonta at the Supreme Court. The plaintiffs in that case have already filed a petition asking the Supreme Court to review the Ninth Circuit's ruling upholding California's magazine ban. That petition has been distributed for conference multiple times, meaning the justices have been considering whether to take the case. It has been relisted repeatedly, which can signal that the court is seriously deliberating rather than simply denying review. Now, with this new D.C. ruling creating a clear and undeniable circuit split, the pressure on the Supreme Court to grant review has increased dramatically. The justices are now looking at a legal landscape where federal courts are in direct conflict over whether magazine bans comply with the Second Amendment. That is the exact scenario that historically compels the court to act. In terms of what happens procedurally with this DC ruling itself, there are a couple of paths forward. The District of Columbia could request a rehearing en banc, meaning they would ask the full bench of the DC Court of Appeals to reconsider the panel's decision. However, there are currently vacancies on that court, and if those seats are filled by judges sympathetic to the Second Amendment analysis laid out in this opinion, an en banc rehearing might not produce a different result. Alternatively, DC could bypass that step and go directly to the Supreme Court by filing its own certiorari petition, asking the justices to review this decision. Either way, the trajectory of this issue is pointing upward toward the Supreme Court. But even if this specific case does not reach the Supreme Court immediately, its influence is already being felt. The reasoning in this opinion will be cited in magazine ban challenges across the country. Attorneys fighting similar bans in states like New York, New Jersey, Connecticut, and Rhode Island now have a powerful new precedent to point to. Courts in those jurisdictions will have to grapple with the DC Court of Appeals analysis and explain why they agree or disagree with it. And there is a formal mechanism for this, something called a 28J letter, which allows parties in pending cases to notify the court of new relevant authority. You can expect 28J letters referencing this DC ruling to be filed in magazine ban cases, assault weapons ban cases, suppressor restriction cases, and other Second Amendment challenges across multiple circuits. The impact of this decision radiates outward into virtually every major firearms regulation case currently working its way through the federal courts. So stepping back and looking at the full picture, here is the key takeaway. A federal appellate court has now ruled that banning magazines holding more than 10 rounds violates the Second Amendment. The court reached this conclusion by faithfully applying the Supreme Court's own framework from Heller and Bruen. The federal government itself supported striking down the ban, and critically, this ruling directly conflicts with what the Ninth Circuit decided in the Duncan case, which is already pending before the Supreme Court. That conflict creates a circuit split that significantly increases the likelihood that the Supreme Court will need to intervene, either by granting review in Duncan or by taking up this case or a similar challenge in the near future. The practical result could be a definitive nationwide ruling on whether magazine bans are constitutional, and the momentum right now is strongly favoring Second Amendment protection. We are in genuinely unprecedented territory when it comes to this issue. The legal groundwork has been laid, the circuit split is real, and the Supreme Court is already aware of the question, what happens next? Whether the court grants certiorari in Duncan, whether DC appeals this ruling, how other circuits respond, will shape the future of firearms regulation in this country for years to come. The dominoes are starting to fall, and the direction they are falling is encouraging for anyone who believes the Second Amendment means what it says. That's it for today, folks. See you in the next video.